Hello, students. I just did the video lecture for Chapter 2 about the First Amendment. This is the video lecture for Chapter 3 about speech distinctions and how those relate to the First Amendment. I'm doing this right after I did the other one. You can tell I'm wearing the same t-shirt. But now my mother-in-law, I call her Nano, is cooking some bindi, that means okra, in the kitchen, and she's listening to some Muhammad Rafi music. If any of you know who that is, maybe you could hear the sounds of Muhammad Rafi coming through the door, the office door there. Just a little bit of local color. All right, speech distinctions. Let's do this. Speech distinctions for JMS 494. As I mentioned in the last lecture, political speech receives the most protection. Advertising, commercial speech receives some protection. Fighting words, libel, obscenity receive no protection. Hate speech is kind of a gray area. It does have some protection, actually, and some offensive speech has protection as well. All right. Speech that promises imminent harm has no protection. I'll try and parse through some of this. The court has adopted several tests over time to protect or to punish disruptive speech, and the border between protected and unprotected speech is not fixed. And sometimes you may even question the decisions that the court has made, but that border is always changing. First up, we have Schenck v. United States, going all the way back to 1919. Schenck was distributing some leaflets urging, I think he was a socialist, urging men to resist the draft. And the courts found that his speech was creating a clear and present danger. So it was not covered by the First Amendment. Okay, that was called the clear and present danger test. Then many years later, or some decades later, we have Brandenburg v. Ohio. And this one, a Klansman, the guy's literally a Klansman, is discussing a march on Washington, D.C., and he said some things that were pretty hideous. But the courts actually found that his speech was protected, and they created something called the imminent lawless action test. Imminent lawless action, that words need to advocate immediate violence. Okay, and he was not advocating immediate violence, and he was also not talking about any one specific individual, just rather entire groups of individuals. That, you know, these people, we should do this to these people. They actually found that, you know, he was not advocating imminent lawless action. So that was a new standard that was created by the Brandenburg case, a new standard created by the Brandenburg case. Now, this one is kind of questionable, but yeah, the courts actually came up with this decision here in this case called Snyder v. Phelps. If you're not familiar with the Westboro Baptist Church, you probably should be, at least for the purpose of this little example here. They like to go to churches and funerals and have some signs. You know, they're very, very extreme, I would say, in their religious views. And the Westboro Baptist Church was actually protesting at the funeral of a Marine who was killed in Iraq. You know, very tragic. They're protesting, claiming that the Lord was punishing the United States. You see this billboard right there. A guy says, "Thank God for dead soldiers." They claim that the United States is being punished because we're too tolerant of homosexuality and marijuana, and therefore, you know, we deserve all these things that are happening. And at first, Snyder's father sued for emotional distress. This was obviously very troubling. You have the funeral for your deceased son, and you have people out there screaming at you. He was awarded $5 million, but then on appeal, the Supreme Court actually found for Westboro's right to protest. They said Westboro had a right to protest. I'm looking at some notes here, and Justice Roberts said that the speech touched on matters of public concern, and matters of public concern cannot be restricted simply because they are upsetting or they arouse contempt. And then the court also said that the content of the Westboro signs did not target Snyder specifically, but rather targeted entire groups of people and dealt with questions of political and moral conduct. I don't know. I don't know if I agree with that. I don't know if I agree with that, but that's it. That's okay. That is what the courts found. Now, there is something called the right to vent anger, okay? This explains how the First Amendment protects people's right to vent, maybe blow off some steam. There's a case, this is in the textbook, Robert Cohen, 19-year-old, wanted to express, a lot of these cases deal with the Vietnam War, wanted to express his opposition to the Vietnam War. So he wears a jacket that says stop the war and also F the draft. I think you know what I'm talking about, F the draft. And he's wearing this inside a Los Angeles County courthouse. Wow, for a 19-year-old guy, that's, you know, he got some nerve to do that. That was okay. You know, the courts found that that was okay. Because again, he wasn't targeted at anyone specifically, and F the draft was not directed at anyone specifically. However, fighting words are not protected by the First Amendment if they are directed at an individual and are intended to cause immediate harm or trigger some violent response. Now, I think what is a fighting word and what is not a fighting word is a matter of great subjectivity, okay? I could say something pretty hideous to someone and someone could say, hey, you're trying to pick a fight. And then I could say, well, that doesn't meet technically the definition of fighting words. So just know that fighting words are not protected, but I think we could debate as to what is a fighting word and what is not a fighting word. Hate speech is, I think we know it when we hear it, is obviously very, very, very offensive. But the courts have actually found that rules to limit that type of speech are often unconstitutional, okay? Hate speech is not a legal term. I'm reading from my notes here. Not a legal term. It is commonly understood to involve name calling, slurs, things of that nature that demean others on the basis of identity. Hate speech as a category of speech includes name calling, pointed criticism based on race, color, gender, ethnicity, religion, national origin, disability, intellect, or something of that nature. It's not actually a legal term. I think we know it when we hear it, but it's not actually a legal term. So hate speech is not illegal. It is not illegal. Fighting words are illegal, could get in trouble, but hate speech is not. And the courts have found, you know, when people try to come out with rules against this type of speech, those restrictions are unconstitutional themselves. A true threat is not protected. A true threat, again, is directed like a fighting word at a specific individual or a historically identified group that is advocating specific harm. For a true threat to be unconstitutional, the speaker must direct the threat towards one or more individuals with the intent of causing the listener to fear bodily harm or death. Now, there's a case discussed in the textbook, Alanis v. United States. This individual, Alanis was his last name, was posting things on Facebook about his ex-wife that seemed to be threats, very, very violent. And the FBI even visited him. And then he started posting violent stuff about the FBI agents that visited him. And he claimed that these very derogatory and inflammatory posts were a therapeutic form of expression for him, that he was working out rap lyrics. And I think he even included some lyrics from Eminem. And this case was in the courts for a long, long time. And ultimately the Supreme Court decided for Alanis, saying that he wasn't specific enough in the threats, and just because the woman perceived them to be threats, they weren't actually threats. So again, that's another case. You can look that up on your own. That's another case with maybe a questionable decision. Now, I apologize in advance for this next image, but it is part of the textbook. Cross burning is considered to be a threat. It is a symbolic act, and by definition, it is considered to be a threat. It is meant to intimidate. It is meant to intimidate. So, you know, posting violent things on Facebook, not a true threat. Cross burning, just by definition, it is. And that was the case, Virginia v. Black. nonverbal forms of expression, which are meant to express particular idea, like burning of the American flag, wearing armbands, maybe with a swastika on them, marching through public streets. These are not considered to be threats. These are generally protected. Okay, these are generally protected because they're a little bit different than some of the other things we've talked about. So these are generally protected. Now, this is a question that has been around. I mean, I'm a media studies professor. This is one of the perennial questions in the discipline. Do media incite harm? Do media trigger people to go out and act out violently? There's a famous case associated with Call of Duty, and I specifically tried to find the oldest image of Call of Duty that I could, because it's a very old court case. Generally, the courts don't buy this argument. When someone, and it's sad, it's tragic, obviously, if your child dies, I mean, it's incredibly tragic, but parents will try and blame, a form of media, a film, a song like Ozzy Osbourne song or something. And the courts generally don't buy this argument, that there's just not enough evidence to explicitly link some horrible violent act to some form of media. However, there's one case, and this is in the textbook, about Soldier of Fortune. Soldier of Fortune magazine had an ad promoting gun for hire, all jobs considered. All jobs considered, okay? And this individual was hired, attempted murder, one of which was successful. And magazine said, hey, we have a First Amendment right to publish whatever we want. In this case, the courts found that no, you should have known what you were doing. And in this case, yes, the form of media did cause some harm. And the term is proximate cause. Okay, the courts will find that a media publisher, media producer is responsible for someone's violent activity. If there was proximate cause, that's the legal term, like you should have known what was going to happen. A mother sued the manufacturer of Dungeons and Dragons game because their child committed suicide. No, the court said there was not proximate cause here. A teenager commits suicide after listening to the Ozzy Osbourne song Suicide Solution. No, not proximate cause there either. Okay. And there are some other categories of speech that's not protected. There was something called the Sedition Act, actually the Alien and Sedition Act, not long after we had the First Amendment in place. I mean, this goes back, hundreds of years. What do you know? The US government passes a law saying you can't, protest the government or try and, cause a riot or a revolution or something like that. The act was really used to punish anyone who had an unpopular political opinion. And then we have the US Patriot Act after the horrible tragedy of 2001. And this was put in place for issues of national security, and we have to keep surveillance on different foreigners, and we have to surveil Americans who are communicating with people outside the United States. I think this was a bit of an overreaction. I think I'm just going to go out and say this, that, maybe there were some area of legitimate concern, but I think it's just a blanket excuse used to surveil people and to lock people up. And we call this the chilling effect. Okay, the chilling effect. You don't necessarily have to punish someone, but if you punish one or two people in a very high profile case, then suddenly everyone else is going to clamp up, tone down what they say because of the chilling effect. All right, that's it. I'm pretty sure this lecture is shorter than the last one. Chapter 2 is probably the longest lecture that I'll do. Chapter 3, this one was a little bit shorter. Anyway, that wraps it up. We're going to go on in the next module to, I guess it's chapter 4. We're going to start talking about libel.